Hi Elena, my name is Sandeep Singh and my student ID is DY31235. We are 5 members in our group and our group is M1.
Hi, my name is Ujjwal. My student ID is NPI 3146.
Hi, my name is Navaldeep Singh and my student ID is PFEC3147. I am the same group.
Hi Alina, my name is Khush and my student ID is EKM3050 and I am in the M1 group. Next is my friend.
Hi, my name is Chamkor Powar. My student ID is EAB3031 and I'm in group M1.
The introduction of case is between Australian Competition and Consumer Commission versus Optus Private Limited. The case revolves around the advertisement campaign launched by Optus with the name of Think Bigger Plan. Optus Private Limited is a large telecommunication organization of Australia which provides broadband internet services. The Australian Commission was a bit concerned about the marketing of one type of plan provided by Optus with the name of Think Bigger Plan. The campaign was launched on Anzac Day 2010. There were two categories under this plan. The first category was the standard plans of 120 GB and 150 GB. And the second one was 170 GB, which was sold by the name of Supersonic. The Australian Competition and Consumer Commission got too keen with regards of this particular campaign, and on 18th June 2010, composed by Optus, described its concern with the idea that the advertisement were misleading. On the appeal of full federal court ruled the order that Optus pay an aggregate punishment of $5.61 million for the 11 repudiation of Trade Practice Act 1974.
Now I am talking about the breach of act of case Optus versus ACCC. There were 3 acts that were breached. The Australian Competition and Consumer Commission put the case on the basis of breach of S52 of Trade Practices Act 1974. It was doubtlessly qualified under the provision that the greater part of the ad has failed to reveal that once the peak data was achieved, no further utilization could be made of the off-peak allowance. Secondly, the case was also placed on the breach of S53AA of Trade Practices Act 1974, which is about that the services are of a particular standard, quality, value and grades. The more genuine fault by Optus was customers was not being sold plan which gave them the designated number of broadband services. Customers were provided with the plans that some of a maximum case of which could be gained, and still at the end just on a watchful basis. And there was another case of the breach of S55A of Trade Practices Act 1974, which forbid conduct which is liable to mislead to public as of the nature characteristics, the suitability of the purpose of the quality of any services. The expression liable to mislead is smaller than likely to mislead. In S52, the plan being referred to did not have that amount proposed to customers at all. For customers at all, they were not 120 GB, 150 GB, 170 GB plan of any of the stretch of imaginations.
So we are discussing about the case 1. In this, the discussion part is between Optus and the ACCC, that is Australian Competition and Consumer Commission. So on the discussion part, Optus depend upon the high volume of the materials that once the customer is drawn into the sales and will placed focus by the proclamation and undercover enough of the general positions. In this first place, it is framed in several different parts, and the part 1 is coming under the promotional campaign, and that took place. And the content of the contract is that they must have to consider it in their assessment to those ability to dilute. But in the second part, regardless to that, all of the debt is not the same. The commercials were to be surveyed for their misleading limit shown of the thoughts what the sales process may form from the point of the comfort to the customer or the consumer, that the material was applicable to the subject of the elevation, that what the court may eventually allows. So at the discussion part in the court decide, and it's completely worthy for the company in the question as well as for the future companies to be careful before considering this act, as we have taken the act as the Flora 2011 discussed in his report that the federal court chose the exhibit that the new powers had the teeth, but as a result, company which are discovered to negotiate the Australian consumer law, they come for a more critical, heavy danger in that. And the given specially, a huge penalties may be found for this and for this kind of the behavior, together with the reputation harm and consistent scores. Sponsors who are sponsoring these ads for the companies, they should be guarantee that they should be careful in considering these pre-production screenings or ads and have the consistent form. Thank you for this.